This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today it's time to explain why it's nuts to assume you are covered without first reading the policy and making sure it provides exactly what you need, and why, at least in Kentucky and in most states, a driver must request UIM coverage if the driver wants to have it. Kimberly Rogers appealed from a judgment of the Fayette Circuit Court granting Lyft Inc.'s motion for summary judgment, Allstate Insurance Company's motion for summary judgment, and Erie Insurance Exchange's motion for judgment on the pleadings, in a case entitled Kimberly Rogers v. Erie Insurance Exchange et al., decided April 19, 2024. The Kentucky Court of Appeals resolved the dispute. Kimberly Rogers was a driver for Lyft Inc. and was involved in an automobile accident with another motor vehicle. Rogers apparently suffered substantial physical injuries, and the driver of the other motor vehicle negligently caused the accident and was insured by State Farm. State Farm paid Rogers the policy's liability coverage limits, and at the time of the accident, Rogers' vehicle was insured by Erie Insurance Exchange, and Lyft carried motor vehicle insurance with Allstate Insurance Company. Both Erie and Allstate denied Rogers' claims for underinsured motorist benefits. Rogers, unhappy, sued Erie, Allstate, and Lyft, hoping one would provide UIM coverage. In Kentucky, Lyft is required by 601 Kentucky Administrative Regulations 1:113 Section 3 Pren 1 close pren to maintain primary automobile insurance that provides coverage both for a driver who is logged into the Lyft application and for drivers engaged in pre-exchanged and prearranged rides. Lyft is also required by another statute to maintain liability insurance, PIP, personal injury protection coverage, uninsured motorist coverage, and UIM, underinsured motorist coverage for drivers who are logged into the Lyft application who are not engaged in a prearranged ride. Allstate insures Lyft under a policy of insurance that the defendant represents only provides the coverage required by the statute as a prearranged ride liability policy, which Allstate contends applies only when plaintiff was carrying persons for defendant Lyft. Defendant Erie insures plaintiff under a policy which it contends excludes UIM coverage for all transportation work and network company activities, whether as part of a pre-trip liability policy or a prearranged ride liability policy. To the extent that the defendant Allstate is contractually obligated to provide UIM coverage to Lyft drivers engaged in Lyft operations in the Commonwealth of Kentucky, and to the extent that the plaintiff was engaged in Lyft operations in the Commonwealth of Kentucky, Allstate is required to provide UIM coverage to the plaintiff in an amount of at least $50,000. To the extent that it was determined that plaintiff was not engaged in Lyft's operations at the time of the collision, Erie is required to provide UIM coverage to plaintiff and not to exceed the limits of plaintiff's policy with defendant Erie. The Court of Appeals rejected Rogers' contention that an ambiguity exists in the exception to the UIM coverage contained in the policy. Under its plain terms, the exception is triggered only if the automobile was identified for business use as indicated on the declarations. Rogers seizes upon the language on the declaration page that identified the use of her vehicle as to work 10 to 14, close quote. However, to work is commonly utilized to indicate that the insured drives the motor vehicle to and from work. Rogers admitted that her vehicle was not rated for business use as required under the exception to the UIM exclusion. Accordingly, the Court of Appeals concluded that Rogers was not entitled to UIM coverage under her policy of insurance. Rogers additionally asserted that the public policy requires Lyft and or Erie to provide UIM coverage, and generally, UIM exclusions in motor vehicle insurance policies do not offend the public policy of the Commonwealth of Kentucky. UIM coverage is only required insurance coverage when the insured requests such coverage. The insured simply may disclose the business use of her motor vehicle and request UIM coverage rated for such use. She did not. In sum, the Court of Appeals concluded that the Circuit Court properly rendered summary judgment in favor of Lyft, Allstate, and Erie, and the judgment of the Fayette Circuit Court was affirmed. In my opinion, insurance, much to the surprise of some, is a contract. It must be interpreted as written. UM and UIM coverage is available in the state of Kentucky if the insured requests the coverage and provides the insurer with information concerning the risks to be taken. Using a vehicle for Lyft is akin to the operation of a taxi cab and is not akin to a person who just drives to and from work. By not properly asking for the coverage and advising the insurer of the actual risks it was asked to be taken, Ms. Rogers had no UM or UIM coverage. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. You'll also gain access to the more than 4,750 blog postings. You can also subscribe to the videos at YouTube and rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.